Sure.
Good evening, everyone. We welcome you all to the first International Victimology Colloquium on victim empowerment through legal and social initiatives, organized by the Center for Criminology, Criminal Justice, and Victimology at Rajiv Gandhi National University of Law in association with the Indian Society of Victimology, Victim Support Asia, and World Society of Victimology.
To begin with, I would like to invite Professor Dr. G.S. Bajpai, Vice Chancellor RGNUL and Chairperson, Center for Criminology, Criminal Justice and Victimology at RGNUL to deliver the welcome address. Sir, please.
Thank you. And good morning, good afternoon, good evening at all places. We have as many as 10 time zones actually meeting in this first International Victimology Colloquium on Victim Empowerment through Legal and Social Initiative. I, G.S. Bajpai, takes this opportunity to welcome all the guests from all corners to this first international colloquium, which is centered on a specific theme being organized at the Rajiv Gandhi National University of Law. At the outset, I take this opportunity to extend my heartiest welcome, greetings, and gratitude to three very prominent speakers who are gracing the inaugural session today. We have with us Justice Gita Mittal ji, whose introduction would be formally given by my colleague, but I can only say that she is one person who has championed the cause of victims of crime through her long stint in judiciary in different states, and she has been instrumental in bringing much needed solace, assistance, and protection through her some remarkable judgments that we have all been studied in last couple of decades. So thank you, madam, for joining. I know you have special circumstances today, but it is her commitment to this kind of academic activities, especially in national law schools, which we are all, it's just so heartwarming to see her today. My special gratitude and respect to you, madam. I also have Professor K Chokalingam, who is again here with us. No amount of introduction is possible from my side because I share a very beautiful, special connect with Professor Chockalingam. I treat him as my mentor, and my whatever little contribution was possible, it was because of his inspiration in my formative years of career. And he is literally considered to be the man of victimology as far as this part of the world is concerned. And through his outstanding work, contribution, writing, and researches, he has impacted the course of victimology, not only in India, but in the international arena as well. And lots of generations actually are getting inspired by his work and his presence in all such occasions. And I'm sure that he would set the tunes for this program today. And of course, I also have my very dear friend, Professor Dr. Robert Peacock. He is the president of World Society of Victimology. And he is again, we have been meeting at different platforms, and I always admire his scholarship in the field of victimology, his commitment to the profession, and his readiness to contribute to the cause of victimology in any part of the world. He would like to be present there and contribute. So very warm welcome to Professor Robert Peacock for your presence today. Friends, when I unfold this colloquium as being first, it means there is going to be second and third also. So I have set up and institutionalized a chain of international victimology colloquium, which would be happening every year in this university or other parts of the country, depending on the conveniences of other partner institutions. And I take this opportunity to acknowledge the partnership that has facilitated the circulation and appearance of this colloquium in the international arena. I particularly acknowledge World Society of Victimology, who is partnering in this International Victimology Colloquium, not only through their support directly, but also in terms of the presence of various friends from WSB who are joining today. I can see Professor Sara, again a very dear friend of mine, is present today, and she is also a part of this colloquium. And also I take a special opportunity and thanks to again my dear friend Mr. Lee, who is the president of Victim Support Asia, and he is also in this gathering today. And I could see that he is one person who has brought a lot of activism in the Asian region by way of setting up Victim Support Asia in South Korea. And I was very pleased to have been there a couple of times. And I am also the vice president of the Victim Support Asia. So my connection with the World Society of Victimology as executive member and Victim Support Asia as vice president and Indian Society of Victimology as president and as Rajiv Gandhi vice chancellor and CCV as chairperson, I'm so pleased to be wearing all hats and caps, being instrumental in this. But I also wish to say that we have as many as 30 very renowned and especially chosen speaker and resource person who are joining in all 5 sessions, 6 sessions that we have in this program. And I can quickly name Professor Janice in first session, Professor Shinrin and Dr. Vipin, Devriti, Dr. Michael, Professor Sara, Professor Somasundram, Dr. Kavita Singh, Professor Arvind Tiwari, Dr. Srinivasan, Justice J.R. Midha, Mr. Sanjay Pulsrest, Dr. Fatima, Professor Deepa Dubey, Professor Jiva from Sri Lanka, Professor Heru from Indonesia, Dr. Hanif Qureshi, IPS officer who is just present, again a very serious scholar of criminology and criminal justice, and of course Beulah, Gilma, and a lot of people, including I acknowledge the kind acceptance by Professor Sandra, a pioneering victimologist who is again present in our gathering today from Liverpool, UK, University of Liverpool. And again, our dear friend Levent Alton from Victim Support Asia is also joining. We have a galaxy of people actually to highlight this. Friends, just I'll take another 2-3 minutes to highlight the core theme on which we are dwelling. As has been mentioned that this colloquium is focused on victim empowerment through legal and social initiative. I recall that long back, it has been said for too long, the victims of crime have been the forgotten persons of our criminal justice system. Rarely do we give victims the help they need or the attention they deserve. Yet the protection of our citizen to guard them from becoming victim is the primary purpose of our penal laws. So with this mandate, we start and we have deliberately chosen the idea of victim empowerment. The idea of victim empowerment is to be reflected through different sessions, which are focusing on 5 core areas, which are the part of this brochure. However, the empowerment, as we understand, it starts with the identification of victims himself in the criminal process, as we understand that the victims are forgotten people in the criminal process. Therefore, the scientific study of victimology is something which is very important to recognize the existence of victim and his role in the crime causation, in crime prevention, and also in terms of mobilizing the assistance to the victims of crime. Empowerment is also about facilitating a process through which the victim can be assisted in terms of restoration, reparation, and comprehensive assistance. Empowerment of victim was intended to provide crime victims a status, recognition, rights, healing, reparation, restitution, and comprehensive assistance. Empowerment is about enabling the victims to have certain rights while facing criminal justice agencies. And as we understand, these rights have been now very well recognized in many jurisdictions, including India to some extent, where we are talking about pre-trial protection, during trial protection, and also the comprehensive assistance. Therefore, right to information, right to participation, right to legal assistance, right to privacy, right to safety, right to speedy justice, right to restitution, and right to medical, social, and rehabilitative assistance are now being voiced as the core concerns for the victims of crime. And I also say that victim empowerment is no longer a charity, as it is about asserting the status and asserting the rights. And as I can see that in a law school, the idea of having a colloquium on victim empowerment is mobilized by the fact that the criminal law, the language of criminal law over last several years have been dominated by the keywords like retribution, imprisonment, incarceration, death penalty. Now this language has to be replaced by the advent of victimology, which brought the terminology like reparation, restitution, healing, forgiveness. So we can see the impact of victimology on criminal laws in the country, where we are exploring the different kinds of ideas. Friends, I have just to provide just 2-3 things just to set this entire, colloquium in perspective. So as we understand that the dimension of this program would focus on generally the causes of victimization, nature of victimization, consequence of victimization, reactions to victimization, and also the victims' rights in the criminal proceedings on which some of our friends would be speaking. I draw certain parallels which are very encouraging in terms of giving us a roadmap for the purpose of providing necessary protection and assistance to crime victims. So as we understand that in several countries after the declaration of victims' own right in 1985, many domestic laws and other regulations have been brought in the existence to amend the domestic laws. I especially would like to mention the EU framework decision on the standing of victims in criminal proceedings in 2001. Now, this EU framework, for the first time in history, brought a kind of legally binding instrument dedicated to the victims of, victims' right, prescribing the European member states' minimum norms for victims in criminal proceedings, and other hard law instruments were soon to follow. So this is what we are actually looking for, that what could be the minimum standards for the victim empowerment, protection, and assistance in different countries, irrespective of the kinds of laws they have. So therefore, increased attention for victims within the criminal procedure met with skepticism and controversy at first time. Many people realize that the victims' rights may impact the long-standing principles of criminal law, which were more and more in favor of the accused. However, this misrepresentation or misconception was quickly dispelled when victimology has now clearly brought out that it is all about balancing the rights of the victim vis-a-vis the rights of the accused. Therefore, we are now these days talking about the rights of the victim in that sense. So overall, what we say that the victim justice is a sum total of all what happened to the victims of crime in a legal system for the redressal of harm done to the victims, including the measures that are developed to mitigate his suffering. So we are actually recognizing an entire territory of victim justice in a very conventional system of criminal justice. And this process of identification of victim was grossly helped by the knowledge that has been generated in the field of victimology. And now a variety of suggestions are being made through which the crime prevention can be made more and more victim-centric. We can also look at a lot of strengthening of victim advocacy and professionalization of victim advocacy, including the licensing of service by the NGOs and by other private actors to the victims of crime, including the fact that there is a Mr. Michael is here, that we have been talking that the UN declaration is high time it should be converted into a binding convention for the nations so that the victims' cause can be taken up more effectively. So I feel that in toto, this colloquium would bring a necessary focus on victims of crime in terms of empowering victims through different laws and different social measures. Social measures have its own course where we are especially talking about restorative justice or other kind of rehabilitative measures. So friends, in these 6 sessions, I'm looking forward to a very thought-provoking discussions through panels. The structure of the colloquium is such where a lot of discussion is likely to be generated by the speaker with the help of a moderator. And I would request that all of you can be present at any time. The link of the session has already been provided to you. And so with this, I open this colloquium, and I wish you all the best, good health, and please greet and please wish this initiative of newly created Center for Criminology and Victimology, which we have set up. And I very fondly recall that in the inaugural, Professor Robert Peacock and Michael, Professor Chockalingam, they were all present when we have discussed that soon we'll be launching some activity under the edges of this center. But I'm extremely happy that the partner institution like World Society of Victimology, Victim Support Asia, Indian Society of Victimology, they have come together to strengthen this initiative of the center. And in the end, I would like to congratulate the team sitting over. They have been doing very hard work in terms of approaching everyone, in terms of asking their conveniences, structuring the program, and making all other arrangements. So this is a wonderful evening today, and I greet you once again. Thank you so much for gracing this occasion. Thank you so much. Over to you.
Thank you, sir. I now take the opportunity to introduce our next speaker, Honorable Justice Gita Mittal. Honorable Justice Mittal was appointed as the Judge of Delhi High Court, where she spearheaded the Vulnerable Witness Court project in the trial courts in Delhi, leading to the establishment of first such courtroom in India. Honorable Justice Mittal served as the first woman Chief Justice of Jammu and Kashmir High Court. The hallmark of Honorable Justice Mittal's judicial philosophy has been a combination of academic rigor, the need to make law and justice accessible to masses, and justice with a human face. Honorable Justice Mittal has been awarded with Nari Shakti Puraskar and PN Bhagwati Award, among many others. Without much delay, I humbly invite Honorable Justice Mittal to share her views on securing victim participation in the trial processes. Ma'am, please.
Thank you. A very good day to all the learned academicians who are part of this, I think, a very beautiful colloquium. I congratulate Professor Bajpai on the initiative which he has taken. He's a pioneer. Wherever he goes, he leads in some unique way or the other. It's a pleasure to be sharing the dais with Professor Chockalingam, somebody who I deeply respect, and Professor Robert Peacock. I look forward to learning from your words of wisdom. I am grateful for this opportunity to be speaking at this very important event. I do not claim expertise or much knowledge, certainly not as much knowledge as the rest of the speakers and participants in this event do. But in my humble way, I have tried to make the path of victims who appear in our courts a little sensitive. I had this opportunity, as you have been told, that we were able to conceptualize a vulnerable witness deposition complex, which was basically intended to remove or ensure that there's no secondary traumatization of victims, vulnerable witness victims, is when they're appearing as witnesses in court. And the vulnerability was attached to age, child victims, victims of sexual violence, the disability, and several other categories. So I will speak about my experience about securing victim participation in the trial process, which is something which I am a little conversant about. I will also speak about a little about the evolution of the statutory provisions and how the judicial precedents have evolved in considering the rights of the victims in the judicial process. It is right to say that in an adversarial systems across the world, the victims have been relegated to the sidelines of the criminal process. In the formal processes within these systems, the role of a victim is limited to that of a witness alone. Little regard has been offered for recognition of victims as rightful participants into a conflict. This disregard is why Nils Christie terms conflicts as property which have been stolen from their rightful owners. This has, by and large, been the situation in our own, the Indian criminal justice processes. These processes seem to have been institutionalized with a singular focus upon the accused or the offender. We are obsessed with the rights of the accused, the presumption of innocence of the accused, with little thought for the rights of the victim. Whatever little space the victims found in our criminal processes, especially prior to the 2009 laws, was where the victims were either the informant or only the complainant. This created an institutional hurdle for victims who were neither informants nor complainants. I had occasion to deal with a similar situation with regard to a survivor of an honor killing. An honor killing, for those of the several foreign friends here who will not be familiar with the concept, is where for some reason, there may be a partner or a partner in a couple who is not acceptable to the family of the other partner. And for this reason, the one of the partners is killed or eliminated. And the survivor of that relationship is actually not the complainant before the police, because it's the family of the deceased who goes to the police as a complainant. So there's a very famous murder case in India called the Nitish Katara murder case, who was Nitish was a victim of was the deceased who was killed because he was in relationship with a young girl called Bharti Yadav. She was the daughter of a huge politician. And Nitish killing put Bharti in a very precarious situation of extreme pressure at the hands of her family. So the complainant of this murder was the mother of the deceased. And I had occasion to deal, and I had said that the survivor of an honor killing, of the couple where one of the partners had been killed in an honor killing, was also to be treated by a victim and entitled to all other rights. This anomaly disabled victims from securing, for example, the right to get a copy of the complaint free of cost, or the right to know if the final report has been filed in the matter by the investigating officer, that is, closing the prosecution. The word victim came to be inserted in the Code of Criminal Procedure by way of an amendment in 2009 by the legislature. Along with the definition, victims were accorded a right to hire a private counsel, a limited right to claim compensation, a right to appeal against the order of acquittal, also to seek a higher sentence, seek a higher sentence or against inadequate compensation. Despite these positive developments, however, not much changed with respect of the role of the victim at the trial. Once the victim registered the complaint or the FIR, the extent of their participation was limited to giving evidence when called upon to do so by the prosecution. Though the Amendment Act of 2009 gave the victim the right to hire a prior private counsel, the role of the counsel was highly restricted. the counsel could conduct the entire prosecution with the permission of the magistrate in their court. In a court of session, the role of the private counsel was limited to acting under the directions of the prosecutor, and such private counsel can only submit written arguments after the evidence is closed in the matter, and that too with the permission of the court. Such exclusion of victims from trial process also received judicial endorsement. In a case of Rekha Muradkar, the Supreme Court interpreted the term assist the prosecution in section 24(8) to infer the legislative intent, limiting the role of the victim's counsel qua the prosecutor. The court reasoned that the victim's private counsel couldn't be given the full right to full participation for a reason that it may have adverse consequences with respect to the fairness of a trial. These purported adverse consequences range from adduction of evidence which may weaken the prosecution case to the trial devolving into a vindictive battle between the victim's counsel and the defense counsel. It is clear from the above, the rights of victims to participate in the trial is undoubtedly extremely limited. The same, however, is not the case in other jurisdictions. You see, we have a wonderful example from the United Kingdom where their code of practice for victims of crimes ensures the right for victims to review prosecutorial decisions about prosecution and charges. It enables the victim to make a personal statement which is considered by the court at the stage of sentencing. Even the procedure adopted by the International Criminal Court allows for the victims to be heard and to air their concerns at each stage of the proceedings. Let us now briefly look at the academic discourse on the rights of the victims in trial participation. Academic discourse has highly advocated the rights and the requirement of victim participation during trial. Ever since the development of critical victimology, the calls for increased victim participation have been made at regular intervals. In the model-making tradition started by Robert Peacock, scholars of criminology, criminal law, and victimology have recommended various models on how such participation can be had at every stage of the criminal process. This academic discourse finds strength from Article 6 of the United Nations Declaration of the Basic Principles of Justice for Victims of Crime and Abuse of Power. It lays down the requirement that victims must be informed of their role and scope in the trial process. Victims should be allowed to have their views and concerns presented and also considered at every appropriate stages of the trial. In the Indian context of the 4 areas where criminal justice processes should take care of victims' interest, Justice P.V. Reddy has outlined furnishing of information at trial stages and facilitating an active role by the victim in the criminal process. The cues as to how such a role can be secured are required to be taken from the Justice Manimath Committee report. This report breaks the victim's right to participate in the criminal trial into precise and achievable rights. The report advocates the right to produce oral or documentary evidence with the leave of the court and/or to seek directions for production of such evidence. The right to ask questions to witnesses or to suggest to the court such questions which may be put to the witnesses. The right to be informed of the status of the investigation and to approach the court for directions for further investigation or to ensure proper investigation. The right to be heard at bail proceedings, the right to be heard before withdrawal from prosecution, the right to argue after prosecution's arguments, and the right to participate in negotiations for settlement of such cases as are compoundable. Very, very important rights, and certainly a very important underlining of which way the legislature and courts may take the rights of the victim. It is certainly necessary to look for greater participation of the victims. Worldwide, the trend has been towards increasing victim participation in the criminal process. There is a huge shift in the understanding of justice. You see, justice is not defined. I say this everywhere. There is no statute, no constitutional provision which describes justice. You see, the winner of the case always says justice has been done, and the loser says grave injustice has been done. So it's in the minds of the perception, but it is for the courts to balance rights, the right of fair trial of the accused against the right of access to justice of the victim. Whereas justice in its retributive sense was the dominant rationale in the past, a greater focus and emphasis is now laid upon the informational, procedural, participatory, and restorative aspects of justice. This shift in our understanding calls for a concerted action, not only from legislatures, but also from the judiciary in order to secure greater participation for the victims in the criminal process. On the legislative front, comprehensive amendments listing out the rights of the victims at various stages of the criminal process must be enacted. Such amendments are not unprecedented so far as the Indian criminal justice system is concerned. A prime example of how such participatory justice can be secured, for instance, for victims of crime generally, is to be found in a law which is known as the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act of 1989. Chapter 4A of the Act comprehensively lists out the rights of the victims and details the manner in which victims are to be afforded the opportunity to participate in the criminal process. This legislation recognizes the victim's right to timely, reasonable, and accurate notice of any court proceeding before a bail proceeding. This law recognizes also that the victim may apply to the court for summoning of parties for production of documents or material witnesses or to examine persons present. Also, the victim has a right to be heard at any proceeding in respect of the bail, discharge, release, parole, conviction or sentence of an accused or connected proceedings, or give arguments and file written submissions on conviction, acquittal, or sentencing. So at every stage, the victim has been given a right to participate in the proceeding. There is no reason at all as to why this very procedure is not incorporated into the Criminal Procedure Code, which governs criminal law, criminal trials in all cases. On the judicial front, a more proactive and victim-centric approach is imperative. For example, the right to file a protest petition against a closure report which is filed by the police seeking closure of a prosecution or a criminal case, or where certain accused are dropped from the charge sheet. They are not arraigned for trial before the court, though not statutorily listed, have been recognized by judicial precedent of courts in India. The judiciary has also recognized the right to legal aid for victims of sexual offences and the right to payment of compensation. In the Mallikarjun Kodagali case, the Supreme Court has observed, I quote, victim impact assessment must be given due recognition so that appropriate punishment is awarded to the convict. To conclude, I would like to emphasize that the need of the hour, therefore, is to recognize victims as very, very important stakeholders of the criminal justice system with equal participatory rights. This does not mean that the values of fairness and due process are required to be diluted. All it means is that the criminal process must be rebalanced in a manner that takes the needs and concerns of the victims into consideration at all appropriate cases. I would once again quote the Supreme Court in the case which I just cited, Mallikarjun Kodagali, and I quote, the rights of the victims And indeed, victimology is an evolving jurisprudence, and it is more than appropriate to move forward in a positive direction rather than stand still or worse, take a step backward. A voice has to be given to victims of crime by the parliament and the judiciary, and that voice needs to be heard. And if not already heard, it needs to be raised to a higher decibel so that it is clearly heard. Unquote. These are very, very valuable words from the Supreme Court of India, and I see no reason at all why the courts do not ensure that the victims' rights are ensured, why the legislature does not take immediate steps to incorporate such provisions as recognize the right to participate of a victim in every stage of a criminal prosecution, right even after the stage of where the victim has lodged the complaint. And we have also recognized, the judiciary has recognized that the complainant may necessarily not be a victim. The victim could be somebody else. For instance, if the victim of a crime is a minor, the complaint would be lodged by a parent or a caregiver or a guardian. So there the victim is not even the complainant before the court. So we actually have to recognize that the victim as a very responsible, essential part of essential stakeholder in the entire justice dispensation system. And what I feel that we have to ensure is that we create a level playing field and ensure that a victim has absolute and equal access to justice, same as what the courts are doing when they are protecting the rights of the accused in ensuring a fair trial. The victim is also entitled to fairness, and a fair trial is as much the right of the victim as it is a part of the rights of the accused. I wish this conference every success, and I look forward to the report which will emanate from the deliberations which are conducted. It is very heartening to know that this is going to be an yearly event, and I am truly gratified by the presence of so many learned experts from across the globe. I congratulate Professor Bajpai once again and his entire team at the RGNUL Patiala at organizing this impeccably organized and conference on a very, very important subject in the criminal justice system. Thank you very much. Thank you.
Thank you, ma'am. Our next speaker for the day is Professor Dr. K Chokalingam. Professor Chockalingam is considered as a pioneer in the field of victimology in India and was the founder president of the Indian Society of Victimology, where he held the position for 13 years. Sir has received numerous international and national awards for his contribution to progressive policy and programs for crime victims. He has been invited to lecture in universities in more than 30 countries. Sir has more than 50 years of teaching and research experience in India and abroad and has authored more than 75 publications, including books, articles, and reports which are profitably consulted by students both in India and abroad. Sir, now I would like to invite you to share your ideas with us on emerging trends in victim justice. Sir, please.
Thank you. Good evening to all of you. Distinguished Vice Chancellor of Rajiv Gandhi National University of Law. Am I audible? Am I audible?
Yes, sir.
Okay, good. Thank you. My good friend, Professor G.S. Bajpai, the Vice Chancellor of the Rajiv Gandhi National University of Law, and distinguished Justice Gita Mittal, the retired Chief Justice of Jammu and Kashmir High Court, my longtime friend and colleague, and the President of World Society of Victimology currently, Professor Robert Peacock, keynote speakers, paper presenters of this international seminar, participants, both in physical mode and virtual mode, faculty members, students, friends, ladies and gentlemen. I'm extremely happy to see so many friends of mine, colleagues of mine from different countries. Particularly, I'm happy to see Dr. Michael O'Connell from Australia and also Dr. Zara. I'm extremely happy that the Center for Criminology, Criminal Justice and Victimology of Rajiv Gandhi National University of Law, Punjab, after Dr. Bajpai has assumed office as its Vice Chancellor, has undertaken the intellectual task of organizing this international seminar on victim empowerment, the first international seminar on victim empowerment for 3 days from 3rd to 5th April 2022, in association with the World Society of Victimology and Victim Support Asia and the Indian Society of Victimology. I am happy to be part of this inaugural ceremony of this seminar on the theme of victim empowerment through legal and social initiatives. I am thankful to Professor Bajpai for his invitation to join this inaugural function and for sharing a few thoughts of mine. At the outset, I congratulate the Center for Criminology and Victimology of the Rajiv Gandhi National University of Law for organizing this national conference on victim empowerment for 2 days, providing a forum for and an opportunity for the researchers and students to engage in discussing various issues relating to empowerment of victims through legal and social initiatives at the national and global level. I am predominantly happy that this international seminar would have papers presented on different facets of victim empowerment. I extend my appreciation and compliments to the organizers of the seminar, as it would give an opportunity for us to make an introspection of the measures we have taken on victim empowerment and to what extent we have succeeded in our efforts to empower the victims, not only in India, but globally. In my brief address, I intend to share a few thoughts of mine on emerging trends in victim justice. Before that, let us examine what the word emerging means. The Little Oxford English Dictionary says that emerging means come up or out into view or notice. In other words, it is something that appears prominent. I recall the golden words of Dr. Martin Luther King, who said in 1963, I quote, "Injustice anywhere is a threat to justice in everywhere. They are caught in inescapable network of mutuality, tied in a single garment of destiny." Unquote. In my view, the paramount and foremost initiative in empowering crime victims through legal measures at the international level came when the United Nations Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power was adopted by the 7th United Nations Congress on the Prevention of Crime and the Treatment of Offenders, held in Milan in September 1985, which was a historic occasion. But I could also participate in that, which was subsequently adopted by this declaration. This draft declaration was subsequently adopted by the General Assembly of the United Nations on 29th November 1985 as resolution number 40/34. Subsequently, a few countries and their governments either created new laws to empower the victims of crime and abuse of power in their countries by adopting the international instrument in their respective jurisdictions, or incorporated those principles to empower victims in their domestic laws gradually. Though during the first 15 years since the Declaration on Victims was adopted by the UN in 1985, the conditions of victims did not improve much globally. After the preparation and production of the two most important documents, namely the Handbook on Justice for Victims and the Guide for Policymakers, many countries have started accepting the Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power, including India. Need for victim empowerment law. In any nation, the high incidence of violent crimes such as murder, rape, car hijacking, armed robbery, common robbery, and serious assaults contribute to widespread insecurity and increased fear of crime among the different sections of the population. The response of the criminal justice agencies and concerned NGOs to victims of crime and violence can mitigate or aggravate such insecurity and fear and can assist in preventing further violence. The absence or inadequate and appropriate supportive services for victims of crime contributes to a vicious cycle of violence and often breeds contempt for human rights, which are sometimes perceived as protective only of perpetrators and their rights. On the other hand, services that recognize and respond appropriately to the needs of crime victims can assist in halting this cycle and help build a culture of respect for others and human rights and build confidence among victims that the society is taking care of them. Almost another most important need of the victims, particularly in India and perhaps most of the developing countries in Asia, Africa, and Latin America, is dignity and respect while being handled by the criminal justice agencies such as police, prosecution, and judiciary during the various processes of investigation, prosecution, and trial. Who is a victim? Now, already Dr. Gita Mittal has mentioned about it, and all the students of victimology are fully aware of it, particularly the comprehensive definition given by the United Nations Declaration of Basic Principles of Justice. I don't want to do it again to save time. Now, victims of crime and violence experience not only the direct negative impact of the crime, which is called primary victimization, but also most often other negative impacts that are secondary to the incident that occur during contact with the criminal justice personnel, resulting in secondary victimization. For example, a woman who has been sexually assaulted may almost experience a second rape when asked to recount what happened in public at a police station. Again, when being examined by a doctor in the hospital who lacks empathy, and yet again when giving evidence at a trial in the court of law. Secondary victimization may be reflected in a wide range of symptoms, ranging from relatively minor discomfort to severe physical, psychological, and emotional trauma, which may result in social difficulties. The impact, nature, gravity, and quality of victimization are not felt equally by all the victims of crime. There are a number of factors that account for variation. Obvious examples being age and access to resources, including the financial conditions of the victim. For instance, when an older person is mugged and assaulted, the physical injury is likely to take longer to heal than when a younger person is wounded in the same way. Older people may also find it more difficult to get to services they require and to persist with what may become a long process of attaining justice. Similarly, a very young child is less likely than the young adult to know how to ask for help or to resist a sexual attack and may take much longer time to recover. Likewise, poor victims of crime, on the other hand, have scant resources to meet the challenges of victimization and often have inadequate access to the criminal justice system. The impact of crime and violence may also be exacerbated by repeat victimization as a result of more than one exposure to crime and violence. What is victim empowerment? Victim empowerment is a comprehensive concept and is an approach to facilitating access to a range of services for all people who have individually or collectively suffered harm, trauma, or material loss through violence, crime, natural disaster, human accident, and or through socioeconomic conditions. It is the process of promoting the resourcefulness of victims of crime and violence by providing opportunities to access services available and build their own capacity and support networks. Hence, empowerment may be defined as having or taking control, having a say, being listened to, being recognized, and being respected as an individual, and having the choices one makes respected by others, moving from victim to survivor. Victim empowerment aims to restore the loss or damage caused by criminal acts and their consequences through a variety of actions intended to empower the victim to deal with the consequences of the event, leave it behind, and suffer no other loss or damage. Safety, safety and human dignity, and that victims should play a more central role in the criminal justice process. Victim support is the empathetic, person-oriented assistance rendered by an organization or individual following an incident of victimization. Through victim support aimed at victim empowerment, the victim is restored to a state as close as possible to that existing prior to the victimization, and ideally to a state where the person has been able to learn and grow. All victims do not have the same degrees of need and empowerment and support. The need for empowerment and support. There is a diversity of needs. In order to enable the disempowered victim to recover from the exposure to crime and violence, such needs must be met through a well-managed, integrated, multidisciplinary team approach. It is generally believed that the empowerment of victims is in a holistic manner reduces secondary victimization, encourages cooperation with the criminal justice process, reinforces socially desired behavior, and acts as a deterrent to offenders or potential offenders. Victim empowerment thus has the potential to prevent and reduce crime and violence and enhance the effectiveness of the criminal justice system. Victim empowerment policy. We must develop a victim empowerment policy with specific guidelines to achieve a society in which the rights and needs of victims of crime and violence are acknowledged and effectively addressed with a restorative justice framework. Thus, the objectives born from this vision are to give strategic direction on the development of management structures for effective coordination of the program at all government levels. Identify and clarify sector-specific roles and responsibilities at all levels of management structures. Guide the process of monitoring, evaluation, and reporting by the implementing structures. Serves as a framework for the development of sector-specific policies and strategies. Identify roles and responsibilities of relevant government departments. Create a common understanding of victim empowerment amongst various government departments, victims, perpetrators, non-profit organizations, including non-governmental organizations and community-based organizations, and individual members of the community. Justification for the national policy guidelines for victim empowerment. In different countries, services to respond to victimization are offered by a variety of both governmental and non-governmental agencies. However, in many nations, services to victims are inadequate, and victims do not access the same services throughout the country, in the same country. Services are unequal and unbalanced, especially in poor communities and rural areas. The disintegrated and uncoordinated approach to service delivery within and across sectors contribute to secondary victimization. While in general, the nations and governments have realized the importance of services to and empowerment of victims in the recent years, these services have not been managed as an integrated whole within and between various government departments, nor with other stakeholders. Even if such services are available, many such support services are not comprehensive and do not comply with the standardized services practiced in developed countries. The manner in which the victim support services operate in many jurisdictions has limited impact on creating a victim-friendly criminal justice system and reducing the negative impact of victimization. Therefore, there is an urgent need for policy guidelines to protect and support all crime victims, especially the weaker sections of the society, including victims of domestic violence and child victims, by ensuring that the victim-friendly services and programs are integrated and coordinated through well-established government structures to prevent re-victimization within the criminal justice system and to maximize the impact of services rendered. Such policy guidelines should provide the framework for sound interdepartmental and intersectoral collaboration and for the integration of effective institutional arrangements for a multi-pronged approach to managing victim empowerment to effectively address the diverse and complex needs of the victims. Such policy guidelines would serve as a guide for sector-specific victim empowerment policies, capacity development, and a greater emphasis on the implementation of victim empowerment programs by all relevant partners. I'm sure that the next 2 days would be the most fruitful days for all victimology symposium participants. And thank you very much for your patience and attention.
Thank you so much, sir. Now it's an honor to introduce our next speaker, Professor Dr. Robert Peacock, President of the World Society of Victimology and Chair of the Department of Criminology at the University of the Free State, South Africa. He has served under several ministerial appointments and also worked as a key commentator for a prime-time crime and victimization television documentary series. Professor Peacock has been a recipient of a number of awards for his industrious work on issues relating to victimization of children deprived of their liberty, victimology of international crimes, and transitional justice. I humbly invite Professor Robert Peacock to share his views on the inequality of victimization, critical reflections.
Thank you so much for that warm and generous introduction. Good morning and good afternoon to everybody, and in particular to our Vice Chancellor, Professor Bajpai, for this innovative pioneering event, which we can share with you as the World Society of Victimology and the Indian Society and our other key regional role players, and also recognition to Madam Justice and also my dear friend, Professor Chockalingam, and members of the World Society of Victimology and all other participants, distinguished. Good welcome to you from us from the WSV. Now, my topic of today is introductory, given the space and given the nature of our deliberations here today. So I think there's a lot to be said about the inequality of victimization, and this should simply serve as some kind of platform to jump off, because traditionally when we do think about victimization, there seems to be sort of, especially in more mainstream circles, to have to focus primarily on interpersonal victimization, whereas my discussion today, I hope, would extend a bit on a narrow orientation to look also at other factors. So having said that and giving our time frame, once again, it's wonderful here, and it's wonderful to be so interconnected as well and so readily, easily available, and just a pleasure, as always, Professor Bajpai, to join you in your innovative exercises. So the inequality of victimization, I'm just referring you first and foremost to the World Inequality Report of 2022, where global wealth inequalities are even now more pronounced, and we can expect this, especially after the COVID pandemic. We see that the poorest of the global population, who barely owns any wealth at all, they are in possession of just 2% of the world's wealth. So this is half of the global population. In contrast, the richest, and this is 10% of the global population, owns 76% of all wealth. If we look at the SDGs of the UN, the Standard Development, the targets, we would see that the issue of inequality is a dominant theme across all of the SDGs. In fact, I think we have seen by the COVID pandemic how the fault lines were exposed in terms of inequality. And highlighting also now here with the war in Russia and Ukraine, I want to highlight here also the plight of war victims, which we sort of tend not to focus on, victims of conflicts. I know there will be presentations later on in the colloquium, but sort of traditionally we do not tend to focus too much on their plight. But we have seen with refugees, we have seen with street children, we have seen how a disease has actually exposed problems which we knew for a long time. Global risks that were ignored for decades, and notably here would be inadequate health systems, gaps in social protection, but structural inequalities, environmental degradation, and the climate crisis, of course. All of this have been laid bare now, and we do find it is the vulnerable in society, the have-nots, the majority who do not have access to resources, who are suffering the most of these consequences. But all of us are exposed to these high levels of inequality simply because it creates economic instability, it creates corruption, financial crises, increased crime and victimization, and poor physical and mental health. So this is a core problem across the SDGs. When we study victimization, to just with reference to Professor Chokalingam's excellent presentation, when he referred to the terminology in terms of victim and survivor, too often we do not engage very critically with these designations, but also importantly, that we do not look also at context enough, where we tend to one stroke for all. So we tend to think in terms of an incident, a victimization incident, as something for which there was no history. Or if we think about the law, we don't see the law in context of geopolitical dynamics, in context with geography, in context with religion, in context with culture, in context with sexual orientation, etc. So that we tend to approach many of our problems in a very narrow way. And one of the aspects that somehow seems to be not really high on the agenda is the historic aspect of inequality. And here I would like to refer to colonization as the historic source of inequality between nations and within nations as well. I think many of you will be familiar that it was especially the colonial rule from Europe that affected the global South for centuries. Through coercion, through violence, we've seen the slave trade. And this long-standing exploitation led to huge inequalities. And also, in addition to the transatlantic slave trade, I must mention, I think South Africa is a perfect example of how bad this can manifest during at the time of apartheid. So colonization affected trade. It also left us with a legacy of economic and social injustice, hate crimes such as homophobia and xenophobia, the criminalization of same-sex relations just on the African continent, punishable by death elsewhere. All of these were imported through the Western legal system and criminal justice as its agent. So this very presence and persistence of institutional and structural victimization were accompanied in the first instance by the importation of Western legal systems, referring here in particular to colonial policing and total institutions, which of course would be prisons, by the colonial masters in order to subjugate and regulate the conduct of the colonized subjects whilst exploiting their labor and their land. Now, colonization, or as it's sometimes referred to as cannibalization, of much of the global south was prompted by the European scramble to colonize Africa. And then, of course, there were other parts in the world as well, South America and also in Asia. And this caused untold suffering. The effects of this still remain very visible at the present moment. African resources, for example, including traditional knowledge, were misappropriated and looted as raw materials for scientific exploration and enrichment. It also shows research of Blaustein, or Blaustein, shows furthermore that many of the development policies and practices of today are rooted in the colonial orientation, that non-Europeans or indigenous communities and colonial subjects were considered backward, trapped in stifling cultural traditions, an obstacle to development, an obstacle to capitalism. So this moral devaluation of colonial subjects were fueled by the exploitation of natural resources and cheap labor, which is also can be called the resource curse. So this ultimately amplified inequalities between the colonizers and the colonies, and established long-lasting relationships of the colonial, post-colonial continuum of economic dependency, reinforcing the underdeveloped label and suffering. So sadly, instead of trade, we ended up with aid in Africa as an example of a continent. But our critical criminologists and victimologists, they've demonstrated some time ago already how these elite politics and these elite political role players, how they uphold their privilege and status and their interest, not only by defining crimes, but also, of course, shaping criminal justice responses to that. Now, the apartheid regime in South Africa serves as a very good example. At the very core of the massive violations of human rights that took place here, lied the need for cheap and a readily supply of labor to ensure the continued exploitation of the country's great mineral wealth by the white elite. And of course, the criminal justice system was used to enforce apartheid rather than curbing crime as in the traditional sense. During times of stress, of course, then marginalized communities suffer the greatest burden of victimization. But unfortunately, these are also the ones who benefit the least from the services and programs made available to crime victims. However, in general, the research of Professor Mark Groenhuizen shows the research he has conducted on the EU directive establishing minimum standards on the rights and support and protection of victims of crime, hard law, shows that the plight of victims of crime and abuse of power is actually not really significantly better than in a more affluent context than what we would expect as in comparison to the global south. In fact, none of the countries in his study were actually in compliance with all of the minimum standards. But with our marginalized victims, we see, and I heard the name Niels Christie just at the beginning of the presentation by Madam Justice, we see that these pure victims, these so-called innocent victims, are the ones who actually access these meager resources, which long before COVID already was a very troublesome and burdensome process to access, usually reserved for health claims, and very little available to crime victims in general. And that was before the COVID situation. So the problem with compensation programs in South Africa, we do not even have one. And I'm proud to see the developments taking place in Kenya when we start talking about access to justice. Compensation programs are usually very difficult to access. So just imagine with the burden of the proof on the aggrieved party, and then this eligibility restricted to the so-called more pure victims. And in terms of the administration of international justice, this situation certainly doesn't look like an improvement there at all. So I think when we talk about access to justice, and we're talking about victim empowerment and inequality of victimization, to understand the impact, of course, marginalization has. So those who suffer the greatest burden of victimization, those offenders we see are more likely to become victims of crime than non-offenders. We have got some theoretical perspectives on this in victimology. We've had our world surveys. We have considerable canons of research demonstrating that once you are on the margins of society, you are not going to access, you already have fallen through support systems. Coming back to the situation of the global south, I think it would also be very useful for us to remain mindful, because our very core business is victim support and victim assistance, that we are also very sensitive about the importation of Western models of health. In this regard, perhaps to remind you of the so-called Nocebo Effect. What happens is that it's described as the nocebo effects in terms of getting access to multidisciplinary assistance programs are different in different cultures, because societies teach their members which illnesses exist, which symptoms indicate the illness, how they are acquired, how they are treated. And these categories may promote as well as describe illness, causing pathologies that they are meant to heal. So just a call that we are also, as we are sensitive around the connotations around crime and victimization and how it became politicized, that we also risk the same dangers that that can be presented by the Western hegemonic medical model, in terms of just assuming that it is culturally relevant and actually causing more pain and prolonging the traumatic experience. So looking at the marginalization and the inequality of victimization, I think the core issue here is that the designation of victim offender label is problematic. You would be familiar with the work of Professor Izzat Fatah in this regard. And I would like to where he refers to the false victim offender dichotomy, the demonization of the one, whereas we have got the the more deserving victim on the other side, and then we've got our disposable groups, our street kids, our offenders who are victimized in prison, our child soldiers, and so the list goes on. So the designation of these labels are problematic because, as I've mentioned in the beginning, it does not really take into account the history, but also, and I think very importantly, a very narrow positivist juridical understanding of conflict distracts from context and the socioeconomic and political dimensions of crime and victimization. And it portrays the offender rather than the state as the greatest obstacle to the well-being of all in the criminalizable event. And I want to refer to those who are more interested in this to the work of Robert Elias, as well as the penal abolitionist Luke Holzman. Now, furthermore, an individual-oriented Western worldview in terms of the labeled victim in particular could be rather ineffective and inappropriate from indigenous perspectives. Well, I think I can take my own country as example. I can take Australia as another example. The experiences we see in the United States, where there's a lack of legitimacy in terms of experiences of law and criminal justice because of these broader problems, the political dimension, the structural issues and concerns around that. So it would be misguided to think of Africa, to think of India as continents who were in complete disarray before colonization arrived. Likewise with the South America. In Africa, for instance, there has been a very sophisticated code and tradition, and many may not be aware of this, but if we look at the principles of Ubuntu, the African humanist values of Nelson Mandela and Desmond Tutu, we see that Africa actually is the cradle of restorative justice, and many of you have been doing some work around that, which are now sort of used quite effectively to rejuvenate the criminal justice system that is in serious need of transformation. So unfortunately, if one looks at crime and victimization without the cultural lens, there is a lot to be lost. And this we had in South Africa, and with the Truth Commission that showed us, that took us back to our roots and in terms of reconciliation, values of equilibrium, non-retributive sanctions, and so forth. So in addition to alien concepts being imported onto the continent, not here, but elsewhere in the global south, I think it would be rather ineffective if we look at the needs of the participants in the conflict situation. And also saying that is, you should be able to relate to that. So if we look at the individual-oriented Western criminal justice system, we see it's not about communitarian values inherent to, say, African tradition, as an example. This worldview is actually quite inappropriate from an indigenous perspective. For instance, African law seek to create offences, seek to create criminals. Whereas within our indigenous context, the tradition has been to rather restore and to maintain equilibrium. So just in short, African humanist worldview would be grounded in the collective, whereas the Western orientation is more towards the individual. Just to share with you, also on occasion on the recent passing on of Archbishop Emeritus Desmond Tutu, that uses the expression of Ubuntu to show to the world and to show to us as South Africans that a person is a person through other persons. Therefore, with this ontological, this orientation in terms of the Mittal, the community, I find it very unconvincing that Western law and criminal justice is central to Africa's history and that of the global South, and seemingly also central to its future. Just referring you also to the phenomenon of secondary victimization, and certainly to avoid repeat victimization, never mind these broader domains and dimensions of structural and institutional victimization imported. So what is the answer? I would think and I would propose that a broader comparative victimology is required, just to assist us to move beyond the simple counting of victims and victim types, but to examine and contrast cultural designations of victims and victimhood, but also to observe differentiation and to see how victims respond to trauma or aggrieved parties respond to trauma with towards a particular incident of conflict. If not, totalizing constructions of victimhood would refer to another form of victimization, namely identity foreclosure. There's so much written on the offender part where the label assumes master status, but very little about the impact of the victim label. We can identify here in terms of drawing from lifespan development, identity foreclosure, for instance, where the victim label assumes master status and, as in the case of the offender label, blinds all other characteristics of the individual or the group, and together also contributes to victim-producing cultures as a result of the shift from the positive to the negative. So with the framing of the victim identity, I think it's crucial that an examination of personal agency and the discrepancies between self-identification and social identification is crucial, and also needs to take place in a broader historical context, and to be connected with the structural and political processes underlying the very process of labeling. So I think also it would be completely outside the scientific framework to attempt to construct an exhaustive and discrete index of various types or categories of victimization, because such a very narrow legal and positivist orientation disregards victim-offender homogeneity, victim-offender sequences, this interchangeability between the roles, to move from the one label to the other. Just think about childhood victimization again and high-risk behavior. But however, Western society and criminal justice as its agent has created what Fatah refers to as a normative hierarchy of categories and diagnostic labels of inferior and superior victims I've mentioned just before. So you've got the guilty, you've got the innocent. There's no consideration for any interaction or interactional approach or lifestyle and routine activities that's being shared. And accepted without denunciation, you are seen as, if you are a member of the LGBTI community, if you are victimized, you would be seen as a deserving victim. You deserve your victimization. If you are a child on the street, you are looking for trouble, you are therefore not worthy of our victimization. So rather than focusing on victim types, I think it would be more useful in addressing the inequality of victimization that we look at the cyclical nature of crime and victimization. Something positive in terms of which Professor Fatah has identified quite some time ago in Montreal at the Symposium on Victimology, when he made reference to the hierarchy of so-called a normative hierarchy of who are deserving victims, a ranking which has become completely unacceptable in other disciplines to consider some groupings as more worthwhile of assistance than other groupings. Having said this, I'm very proud to share also, and I'm very happy that the Secretary General of the WVC, Michael O'Connor, is here with me. We work together as part of a core group on the launch of the model provisions of measures regarding access to justice for victims of crime, that was now launched recently by the UN Office of Counterterrorism, the Interparliamentary Union, and the United Nations Office of Drugs and Crime. And here it was emphasized the following. It says, emphasizing that measures to support and assist victims of terrorism and ensure non-discrimination and equality among victims of all crimes, to avoid creating any hierarchy among victims, and that any difference in treatment afforded to victims of acts of terrorism, as distinct from victims of other crimes, should be based upon their specific needs in accordance with international law. This is very progressive, and I think this is incredibly an advancement, and it would therefore also accommodate offenders as victims, which has never really been always that much or that well understood. Yeah, I think liberty is seldom found in law only, and paper rights may sort of chiefly serve to mask the hegemony of disenfranchised groups who are participating in their own oppression. There's very little reason to assume that criminological and victimological interventions, development programs, or economic reforms can ever fully resolve the underlying causes of many victimological harms that affect the so-called developed or developing countries, unless and until they lead to greater equality, freedom, and justice. Maybe just a note, the noise you hear in the background, we get very severe hailstorms, so there's a hailstorm taking place, so my apologies for that. But when we are dealing with these underlying causes of victimological harms, also to remain mindful, often we see the emphasis very often on the rule of law. But we need to also understand that it can be counterproductive as well in terms of crime and victimization, because it does not, number one, address the root causes of crime and victimization, but also proactive policing has shown to be discriminatory, targeting certain groups. So even with the rule of law, that we remain very critical in terms of, is it really sort of addressing these great harms in society? So, yeah, rather than for us to psychologize away social and economic inequality and environmental degradation, I think a framework of justice, reconciliation, and reparation is required that locates crime and victimization in a multifaceted context of history and geopolitics and structural victimization. Otherwise, the poverty not to engage with the ongoing consequences of colonization can be considered a reproduction of colonization. I think I'm just going to stop there for a second, just to see in terms of the audio. Are we still good with audio? Yes.
Okay, sir.
Are we still good with audio? Sorry, there's an extreme storm outside. This is Africa happening, but in conclusion, so we need to engage with the ongoing consequences of colonization. Otherwise, we end up with a reproduction of colonization. And in order to do that, we need a framework that transcends the legacies of economic, environmental, and social injustice. But this necessitates a recognition and acknowledgement and redress of the links between poverty and the current world economic order in order for local, national, and regional role players to be finally viewed as co-owners of victims' concerns. This would enable us to advance an emancipatory agenda of a people's-oriented victimological discourse. I thank you so much.
Thank you, sir. Now I would invite Mr. Ankit Kaushik, Assistant Professor of Law at RGNUL, to deliver the vote of thanks.
Good evening, everyone. So I'm honored to have been asked to deliver this vote of thanks on behalf of the Center for Criminology, Criminal Justice and Victimology at the Rajiv Gandhi National University of Law, Punjab. So we are extremely thankful to all the guest speakers for sparing the time and making the efforts today to grace us with their presence. We are thankful to Justice Gita Mittal for her words of wisdom and for her continued association with us. We are thankful also to Professor Dr. K Chokalingam and Professor Dr. Robert Peacock for enriching us today with their riveting addresses and also for continually guiding CCV as advisors. We would also like to thank in advance all the panelists and moderators who have spared their time and most graciously agreed to be a part of this event. We would like to thank Professor Dr. G.S. Bajpai, Vice Chancellor RGNUL and Chairperson of CCV, for conceiving the idea of this colloquium and for continually spurring and inspiring us to conduct such path-breaking events. We would also like to thank Professor Dr. Naresh Kumar Vats, Registrar, for providing us with the support and encouragement for this event. We must thank our faculty colleagues, without whose support, teamwork, and efforts, the conduct of this event would not have been possible. Particular mention must be made of Dr. Ibneet Walia, Dr. Shruti Goyal, Dr. Gurneet Singh, and Dr. Arjun. Last but not the least, we would also like to thank all the persons who have registered for the colloquium and who are connected with us today. The overwhelming response that we have received from across the country and across the world It has been a great source of encouragement for us. So thank you so much.
Thank you, sir. With the kind permission of the Vice Chancellor, we would like to close the session for today.
One more, Shruti, just to make a small announcement that the colloquium brochure has already been circulated, and I would request the colleagues and all other friends to please be there in respective session. You are welcome to join all the sessions, in fact. And today is particularly the presence of Michael O'Connell and Professor Sarah and Janice and all the friends is especially acknowledged. And thank you so much for gracing this occasion today. And I'm looking forward to your continuous presence in different sessions. And please feel free if you have any query or if you have any suggestion to make these sessions more vibrant. We would be look up to that. So thank you from my side. Now over to you, Shruti, to you.
Thank you, sir. Thank you all for joining us. We will be meeting you tomorrow at 10 o'clock in the morning for the sessions. Thank you. So
Thank you,
would
Vanessa.
you like to close, sir?